Hello everyone, my name is Kevin Chu and I'm an associate attorney at Geng Associates PC. Today I will be discussing contracts with you all because contracts is a very important part of our everyday lives and it's integral to many business transactions and the way that law sees different agreements that individuals and businesses make. So a contract centers on promises that people or businesses make with one another, and it usually is something that, if valid, the law deems as being enforceable, meaning that the promises are exchanged between different people, and if the agreements or the promises that are made are not followed, the law will come in and actually enforce those agreements. So aside from the actual promises, there's also agreements about what happens if the terms or promises in a contract are not actually met. An example would be if I hire you to paint my house, I might dictate when you'll come paint the house, what materials you'll use, what the color of the paint will be. And if you don't actually follow what we agreed upon, then what will happen is the contract might say what my remedy is. While contracts can be both oral and written, there's a few classes of contracts that must be in writing and signed by the parties involved in order for the law to actually provide that extra protection to enforce the agreed terms and the promises that were made. So there's actually five types of these. And the first one is actually marriage. So marriage agreements are an agreement between two people to marry one another, recognized by state law. And embedded in that agreement, there might be prenuptial agreements or separation agreements. Those must be in writing. The second type of contract that should be in writing is contracts that can't be actually performed in under 1 year from the date of the agreement. The next type is a surety contract. So that's a contract where one person promises to be obligated for the debt of another person. The law wants that to be in writing. Then there's a type of contract called UCC, or the Uniform Commercial Code. That pertains to sales of goods. So contracts for sales of goods over $500 also need to be in writing. And then the last type is a real property or land sale contract. So any transfers of land or agreements should also be in writing. There's actually some special types of contracts that don't involve promises. The first type is something called restitution theory or unjust enrichment. So this type of contract, or what the law would call a quasi-contract, occurs when one party gets a benefit or compensation that they held onto, and the law deems that that person that conveyed that benefit to the person retaining it actually compensates that person. The second example is reliance theory, and the Latin term is promissory estoppel. So this is a type of quasi-contract that arises when there's no promise made by both parties, but maybe one promise was made to somebody, and the person that heard that promise changed their position and relied on the fact that that promise would actually occur. So hopefully today you learned a little bit about contracts. We went over what a contract is, what contracts need to be in writing for the law to enforce it, and two types of special quasi-contracts in which a legal claim could arise. Thank you so much for watching, and if you ever require some sort of contract review, drafting, or consultation, feel free to go on our website, call our phone number, and schedule a consultation with us. We would love to have you.